Mr. Rothschild, is there anything in the Mahmoud decision that would allow a parent or group of parents to veto information given to other children other than their own?
Part of the problem with the decision in Mahmoud is how confusing it is. On the one hand, it presents itself as very narrow, an interpretation that was echoed by Mr. Baxter, and the court goes on and on for about 10 pages explaining how indoctrinating these picture books were, suggesting that that would be the limiting principle. But then, somewhat cryptically, Justice Alito adds a paragraph at the very end saying, in any event, it doesn't matter. Essentially, everything that I just said doesn't matter. And the only question is, does this interfere with the parent's ability to instill within their child their religious values or their religious beliefs? There's no endpoint to that.
Well, but they can opt their own children out. Can they veto the material being shown, presented to other children?
Ostensibly not, because the decision is framed around opt-outs specifically.
Okay. Now, to opt out, do you have to have a legitimate claim of religious liberty, or can you opt out for values or opinions, like I don't want climate change presented, or not for religious purposes, but I just don't think LGBTQ material ought to be presented to that. It's just age inappropriate. Do you have to have a legitimate claim of religious liberty?
Mahmoud is a religious liberty case, yes.
So you just can't opt out on opinion?
Right.
Alito had some other information in there about a threat to religion. It can be contrary to your religion. Does it have to be a threat to your religion?
Well, that language of a threat comes from Yoder, where the threat that the court is articulating in Yoder is a threat to the survival of this distinctive religious community, the Amish community in Wisconsin. So it somehow gets transported to opt-outs in public schools, even though Yoder is talking about opting out of compulsory education laws for 2 years, the ages of 14 to 16, under very specific circumstances. So the language of threat now is used in Mahmoud to suggest that so long as anything in the curriculum threatens the parent's ability to instill the parent's religious values in their children, that threat is constitutionally protected.
Okay. Is there any consideration being given in this decision to the harm that may be inflicted on other children when they see some of their classmates opting out? All of a sudden, it puts a different view on the material they may be given. Is any consideration being given to the effect of all these opt-outs on the other children?
The court gives no consideration to that. It just dismisses it out of hand. So one of the arguments that the board made was that there's inherent value to teaching inclusivity to children, and you can infer from that that it very much undermines the message of inclusivity when a group of students, stand up and walk out. It's like a walkout, essentially, from that particular teaching. And the Supreme Court was just extremely dismissive about that particular interest that the state had articulated. And finally, if you have a complaint about this, what agency in the federal government would you seek guidance from? Would it be the Office of Civil Rights in the Department of Education? I would assume so.
And are you aware of what's happening to that agency? Being dismantled along with the rest of the department?
Yes.
Thank you, Mr. Chairman. I yield back.